Every day in the USA, people find themselves in court.
Yesterday when we adjourned that Ms. Grammond was on the witness stand, so Ms. Grammond, if you'll come back, please. Holly, you may examine your client.
I have no further questions for her. I'm good. I don't know if there's any.
Do you have questions for her, Ms. Hendrickson?
No, I don't.
Then you can step down.
Thank you.
I would call Patricia Grammond her mother.
Patricia Grammond. I'm sorry, what's your name?
Patricia Grammond. Patricia Grammond, her mother.
Holly?
Yes, sir. Ms. Grammond, state your full name for the court, please.
Patricia Ann Ray.
So I'm calling you, I'm sorry, it's
That's
not
okay.
Grammond. It's Patricia Ann Ray, R-A-E?
No, R-H-E-A.
R-A-G-A, all right. And you're the mother of Tony Grammond, correct?
Yes.
You had an opportunity to supervise some of these visits, have you not?
Yes.
How many visits would you say that you supervised?
8 to 10.
And these visitations that you supervised were because the forge had a conflict with time frame, correct?
Yes.
And that was was that by agreement of the parties?
Yes, and I agreed to help out.
Okay. I'm going to approach.
You may.
We'll show you a picture that we introduced as evidence already. I want to ask you if you recognize that picture.
Yes.
And what is that picture?
It's a picture of Brian and Pearson in the commons area where we would meet, and Brian with the gun in his back of his pants.
Did you take that picture?
I did.
Did that picture cause you concern?
Yes.
What concern did you have when this was going on?
Well, I was worried that, number one, for Pearson, to possibly be hurt by it or grab it, or I mean, I don't know a whole lot about how easily a gun can go off. Also, I kind of felt intimidated by it. Why is he doing that to where I can see it?
Were there anybody else in the room with you and Mr.
No.
Grammond at that point?
No, just us. It was always just us.
And did he know that it was just you coming to the visitation to supervise?
Yes, that's how it always is.
How did you feel about somebody needing a gun to protect you from them?
Ridiculous.
Did you have opportunity to see other weapons on Mr. Grammond during these visitations?
I did on
Explain that to the court, please.
Yes. I also and he had a knife on his, I guess it was on his waist because it fell off as he was walking past me, and it fell and hit the floor and opened up.
How big a knife was it?
Well, once it opened up, I don't know, maybe like that.
Do you feel like Mr. Grammond did that and had the gun there to intimidate you?
Possibly.
Did you see or hear anything in regards to the interaction between Brian Grammond and Pearson that, as a supervisor, caused you any alarm or set you back any?
Yes, I would watch Pearson to see how he reacts with his dad. On one occasion, Brian asked Pearson in an angry voice, "What did you call me?" Just asked him again, "What did you call me?" I don't know if he thought Pearson called him Brian, because I actually didn't hear what Pearson said. And of
What was
course,
Pearson's reaction to Mr. Grammon's words then?
he just looked at it like this, just kind of looked stunned and not knowing what to say. Looked maybe a little scared, just not knowing what, what am I supposed to say? He's 2 years old.
Objection to speculation.
Well, Judge, you
And it
testified
would
what you
seem to be
witnessed.
speculation.
I'm sorry.
It would appear to be speculation. You have some way that it wouldn't be?
I thought what you testified to is what you actually observed on Pearson's face when Mr. Grammon said these words to her. It's what you actually saw and observed from her vision.
She can testify about what she observed, but interpreting what she observed is the problem. She can testify as to the expressions and reaction, but again, being able to testify and interpret that as meaning certain things would be speculation on her part. Anything else, Ms. Hendrickson?
So just to be clear, as far as you witnessed his reaction, can you describe what you witnessed to the court?
He looked stunned and speechless.
All right. Did you have opportunity to hear Brian Grammon try to get additional information out of Pearson?
Yes,
Explain that to the court.
yes, a few times. There was times when he asked Pearson, where did your mother take you today? Did she take you somewhere? And he was like interrogating him to ask him, what has your mother done today? Did she take you to work with her? Did she go somewhere? Another time he said, did she go somewhere this weekend? Did she leave you with somebody? How did that make you feel? And Pearson is, again, speechless. So he did that 2 to 3 times when he would come in there, just trying to get information from Pearson about Tony.
Did you ever talk to Mr. Grammon yourself about the gun or the knife at all?
Yes.
Did you bring that up? What did you say to him?
Initially, the first time he brought the gun, I asked him, why do you feel the need to bring a gun in here and into a church and to visitation? He said it was his right and it was safe. Pearson couldn't get it. And so he brings it again to another visit. And so finally I took a picture because I was put out with it and I just didn't know what else to do, so.
Fair enough. That's all I have.
Hendrickson?
Good morning, Mrs. Grammon. I represent Brian Grammon. Isn't it true that there were times when you would tell Mr. Grammon that you were available on the days that he requested for a visit, but your daughter refused those visits?
No, that is not true.
So you never told Brian, oh, I was available that day. I don't know what happened. You never did that?
No, I did not say that.
Okay. Now, the gun situation, after you took the picture and gave it to your daughter, isn't it true that you had never seen him bring a gun anymore?
That is true. He did not bring it anymore.
How about a knife? Have you seen him bring a knife after that incident?
No, he did not.
Okay. Do you recall when Mr. Grammon went to your house to try to see Pearson and then the police got involved? You
Yes.
recall that? Were you there?
Yes.
Do you recall your husband brandishing his own gun to Brian?
No, I did not see that.
You did not see that? Okay. Isn't it true that y'all refused Mr. Grammon to see Pearson that time, even though you had a police officer there?
Right, we did refuse.
Okay. What was the reason for the refusal?
Brian had wanted to see him, but Tony and we were very fearful of him at this time.
Did he have a gun at the time?
I don't know. He always,
Did you see him when he was trying to see Pearson? at that time, that moment?
Did I see Brian?
Yes.
I saw him out the window.
Did
Come
you
out.
see him carrying a gun at the time?
I couldn't see. I was far
Was
away.
he threatening you all that he's gonna inflict injury to anybody? Was he verbally threatening anybody? Or was he just trying to have a glimpse of Pearson?
I could not hear him. I was in the house.
Okay. At any point in time when they were still living together, isn't it true that Brian told you and your husband of your daughter's physical abuse upon him? You remember that?
I remember Brian telling me one time that Tony hit him.
Okay. And so, do you feel that's right to do to your husband?
To hit my husband?
To hit anybody? Is it?
If we're objecting to speculation, Judge, I'll object to
I'm
speculation
asking for her
as well.
opinion, Your Honor.
When Mr. Holly is making an
Sorry.
objection, I know you would love to be able to respond as quickly as possible, but wait for him to finish so that I can understand what he's objecting to. He's objecting to speculation on, she would have to speculate in her answer, is that correct?
Yes, sir.
All right, his objection is that the witness would have to speculate to answer the question. Now you may respond.
I'm simply asking what the witness thinks about the rightness or the wrongness of someone physically assaulting another person, such as in this situation.
Okay. Overruled. Repeat your question, please.
Mrs. Graham, I'm just simply asking, is it correct or right of your daughter to physically abuse her husband?
Well, I don't think she physically abused her husband, but I don't think it's right to hit anybody.
So hitting is not physical abuse to you?
I don't object to that being all argumentative.
Today's
She's,
argumentative.
I'm moving on. Have you seen your daughter discipline Pearson?
Yes,
How does she discipline Pearson?
depends on what he did. Can you be
Okay.
more specific?
Has she used foul language on Pearson?
No,
Has she screamed at Pearson?
no.
Okay, so you just testify that you've seen her discipline. Just if you can just tell me what type of discipline have you seen from your daughter?
She does time out at this point when he misbehaves. She will talk to him. I guess you could say, fuss at him. You raise your voice a little, you don't do that.
Okay.
Or,
Is there anything else that you haven't seen her grab Pearson from just one arm and lift him up
No.
when she's frustrated?
no.
Isn't it true that you and your daughter had a cleaning job at Mr. Grunn's business place in, I want to say Nashville, correct?
Yes,
And that office had exotic animals in there, such as snakes and all those things.
yes,
And you all had Pearson with you.
yes.
How old would Pearson be at the time?
From the time that
You started
we
cleaning there.
started.
Mhm.
How old? I'm guessing because I know he was really little,
Just
so a year?
So, okay, was he walking already, or did he have to
No.
be in the?
No, was not walking when we started.
Okay, and then he eventually started walking, is that right?
Yes.
Okay, so who would be keeping an eye on him when y'all are cleaning the office?
I usually cleaned the office, that office.
Okay, but there were times when your daughter was with you in Pearson, correct?
But the office you're talking about is separate from the whole building. It's a
Okay.
door. It's just that's the owner's office. So I usually cleaned it because I'm a little particular since that
Okay.
is his office.
Yeah, I'm particular too. Well, so, but there were times when, so are you saying that that's a big building and you're specifically in the office? So what's the other part of the building?
It's full of instruments.
Okay, and so where would your daughter and Pearson be?
They could be on the first floor, which is the showroom,
Okay.
which has a lot of instruments.
Would
That's all they
would
say.
Pearson be with her every time she would be cleaning the place?
Would he be with her the whole
I'm
time?
just trying to figure out where Pearson would be when y'all are there cleaning, whether you're in the office or if she's in another area. Where is the Pearson be?
Well, we used to take a pack and play, a play pen that you can
Okay.
fold up. He was in there a lot.
Okay. And what kind of chemicals did you use to clean the place?
Mostly window cleaner, glass cleaner.
Okay, so Pearson would be exposed to all these things that you were using.
No, we kept him away from when we sprayed or wiped anything down.
So where would be the pack and play be?
Kind of to the middle of the room
Okay.
because we didn't want it near, they've got expensive instruments, so we'd usually, and it had wheels, so if we walked over to this end of the room, we'd wheel him with us.
Okay, so wherever you're at, he's there and you're using all these chemicals, correct?
Just glass cleaner on the glass.
What else do you use for cleaning? Seems to me like it's a pretty big, undertaking. Is that all you use to clean the building? Just the window cleaner?
A lot of vacuuming,
Okay.
mostly vacuuming, taking out the trash.
So you're saying that you're only using a window cleaner to clean that office?
The floor and then mopping the floor.
What do you use for mopping the floor?
I usually use like some kind of floor cleaner, like Mr. Clean, pour it in the container on the mop. It goes inside of there, you close it, and it squirts right at the floor, like a Bona mop. I don't know if you know what that is.
I use
So-
Bona.
Okay, so that's pretty much what I spray the floors with that, so there's not a bucket for him to get into, or
Okay.
fumes.
Well, isn't it true that when Mr. Graham found out about this, that he stopped it, correct?
Stopped what?
Your daughter bringing Pearson to that place, because he just didn't think it was safe for him to be around all these exotic animals and cleaning materials that are just not, good for a child to be exposed to.
No, that is not true.
Did you hear Brian tell your daughter?
No,
So you won't have personal knowledge of it, right?
he told me.
Okay, what did he tell you?
He told me she's not cleaning with me anymore because he was mad at me.
Because what now?
He got mad at me
For what?
because he read a text that I sent to Tony
Okay.
because she was, they'd been fighting. She was very upset. I knew he would read the text.
What is in the text, do you recall?
I told her that she would be better off without him.
Okay.
So he said she could not clean with me anymore.
Okay. But it's true, partially at least, that he had requested for Tony and Pearson not to go in that specific location.
So no to
No.
object at this point. This is ask and answer. She plainly said no to this question already.
Exactly, what is the point of all this?
Well, just subjecting the child, mother and grandma and mother, subjecting the child to this situation that should not be.
And that
But I
is,
will move on, Your Honor.
that is cleaning this building.
With exotic animals and using chemicals?
Let me ask this question. Whose building is this?
Mr. George Gruen, it's Gruen Guitars,
Okay.
in
And where is it
Nashville.
located?
8th Avenue North.
In Nashville?
Yes.
Okay. And what kind of exotic animals exactly are we talking about?
Snakes. He likes snakes.
You let them run around loose
No,
in the
sir.
building?
They're in,
Uh,
is it
What do they
okay?
call it? Not aquariums, but some sort of a glass enclosed case.
Right.
What kind
many
of snakes are they? Are they-
I don't really know. They're big. A lot of them are big, and
How
some
many
of-
snakes does he have?
Probably a dozen.
Did you ever see the movie Raiders of the Lost Ark?
Yes.
The lion, snakes, it had to be snakes. Some people don't like snakes very much. I'm not fond of them, although I've handled quite a few in my life. But I will say this: is there any reason your grandson has to go with you all to clean house, or she doesn't clean with you anymore? Is that correct?
That is correct.
All right. So whatever happened before she stopped cleaning.
Yes.
All right. And was there ever an incident where any of those exotic animals were loose?
Never. They're always in a cage with a lid on them, and they clamp down so the snakes
So
cannot.
that's the
get out.
snakes. What else? What other kind of animals are
A
there?
turtle. And
Is
it's
it a
also in an
dangerous turtle?
enclosure. No, sir.
Snapping
cat.
turtle, for example, anything like that?
No, because I have handled it before, and it's not
What else?
a cat.
What kind of cat?
It's a regular house cat.
Okay. All right. And those are the exotic animals that we're talking about. I don't, Ms. Hendrickson, I know you said you were going to move on, but I had those questions in my mind anyway, since there was an objection to it. But apparently this is something that happened in the past, and
But
I
it
don't
still
particularly.
shows her decision-making abilities, but I'll move on. If I can just look at my notes real quick. Mrs. Graman, in the event that Judge Wolfe continues to order the supervised visitation, would you be agreeable to supervising it at Brian's home?
Where, I'm sorry.
At Mr. Graman's home?
Okay.
No.
Okay. What's your concern about that? Is it just inconvenient for you, too far, or?
I guess I don't feel comfortable.
Okay. Were you aware that he has been attending, he did attend anger management classes, attended parenting classes? Are you aware of that?
I am aware of that.
Okay. And he's gotten his driver's license. You aware of that?
Brian told
Just
me.
yes or no, ma'am?
Brian
Are
told
you
me that he
aware?
did
Okay.
get, Brian told me he got his driver's license after
Okay.
we had asked him for years to please get your license.
And he did.
And he would not do it. He
Ma'am,
said
I'm
he
just
did not
asking
want
if
to
you
do
know if he has a driver's license.
it. Yeah.
Are you aware that he has attended a CPR class for children?
I think he told me that he did that.
Okay. You aware that he attended some courses on gun safety and all those things?
He told me he did.
Okay. Were you told about the situation with his apartment where he's not permitted to bring alcohol or drugs or anything like that?
Repeat that?
Are you aware that in his apartment lease, he is not permitted, or at least it's forbidden, to have alcohol or drugs in the whole community? Are you aware of that?
Judge, I would object to the relevance, kind of with this line of question. I let a couple of questions go, but I don't know what this has to do with any
I think
relevance.
Ms.
as
Hendrickson
to-
was trying to establish that there have been changes in Mr. Graman's life that he has affected, that she's questioning whether or not she would feel comfortable going to his house to supervise visitation, and asking her if she's aware of these changes he made. Am I correct?
Yes.
That's the purpose of your question, overrule the objection.
You recall the question? You want me to read?
Read it.
I think I was asking you whether the apartment lease that Mr. Graham signed, if you're aware that the lease prohibits any tenant from bringing in alcohol or any illegal drugs, and that the management has authority whenever they want to go into the house and inspect. Are you aware of that?
Yes, I also rented to Mr. Graham, and that was in our lease too, no drugs or alcohol. But it did not stop him from doing that. I found pot, drinking, he did not
Did you call
care.
the police on him when you found pot?
No,
Isn't it true that at some point during the visits, you had told Mr. Graham that you were okay to supervise at his house? So that it'll be more comfortable for the child?
repeat that.
Isn't it true that in one of your in one of the supervised visits where you were supervising, that you told Mr. Graham that you would be agreeable to supervising at his house, so there'll be more comfortable and more natural environment for Pearson?
I remember him asking that, but I never agreed to that. I remember him saying it would be much better where he could see his own room and be more,
Yeah.
just more easier for him, but I never agreed that I thought that was a good idea or that I would go there and do that.
Your Honor, if I can make confirm with my client. Okay. Mrs. Graham, you just testified that it'd be better if he's in his room. Would you be agreeable if he does it in your home? With your, whoever will be the supervisor? If the judge continues to supervise visits?
In my home,
Yes, ma'am. With orders in place about restricting of no guns, no drugs, no alcohol, the Judge Wolfe will surely, and I'm taking a step forward here, if in the event that the supervised visits will continue, Judge Wolfe will probably put in some restrictions there to safeguard the supervised visits. Would you be agreeable to that?
I think there has been too much that has gone on in my house that my husband and I have witnessed of Brian screaming, cursing, not only my daughter, in front of her child. No, it's just not, it's not a good idea. There's too,
Yeah, if there's an order that says Brian can't do this, this and that, and you all let him go if it happens, and, the lawyer can file a contempt for violation of the orders, you are going to have some type of an order. If the judge wants to do that, do it that way, you would still not be comfortable.
not in my home.
That's fair. I have no further questions.
Mr. Hawley?
Testified you didn't feel comfortable with Mr. Graham. What's the biggest reason you don't feel comfortable with Brian Graham?
Brian can be very vindictive. I've seen his explosive behavior, not only to me, to my daughter, and in front of Pearson. I've seen him scream, rant, and rave in my home. They lived with us for a few months.
When he gets in that mode, can you control Mr. Graham?
No,
Or your testimony would be he would be out of control at that point, you wouldn't be able to do anything?
that's right.
And Mr. Graham, I think according to your testimony, he violated some rules you had before when he lived with you, or was over at your house. What rules were those?
My husband told him that he could not have any pot, which he has told me he has to have every day, cannot go without a day without smoking. We told him it could not be brought on our property. No alcohol. We also don't allow alcohol at our house. That eventually was found. So he did what he wanted to do. You can ask him or tell him these are the rules. But he
Did you
will.
go back to Mr. Graham then and say, hey, we found alcohol and drugs? You need to get him out of the house?
No. No, well, I'm not to my knowledge.
That's all I have.
Follow up, Your Honor.
Have you seen Brian physically abuse or put his hands on Pearson at any point in time?
No.
If I represent to you that Mr. Graham has not had any illegal drugs, which is marijuana, since the separation, that would have been 6 months from that time. And he is willing to do whatever drug screen the judge orders. Does that kind of help alleviate some of your concerns?
No.
That's all, Your Honor.
Mr. Holly?
You ever heard Mr. Graham threaten Pearson?
I have not heard him threaten him, but during the visitation, he has said a couple of things, asking Pearson, do you have a dirty diaper? And you better not be lying to me. Telling a 2-year-old, you better not be lying to me, because Pearson will always tell you no. He doesn't want his diaper changed.
So he ever told you to do anything you felt like was inappropriate to Pearson?
Yes.
Tell the court.
One day I was at their house and Pearson pulled my glasses off like this. He likes to play with them. And I don't mind it, but Brian did, and he told me to smack the shit out of Pearson.
Nothing further.
Nothing further, Your Honor.
Thank you, ma'am. Let me ask this question. When the visitations occur at the Church of Christ there in Alexandria, who all is present for that?
I am the sole person supervising, and then Brian and Pearson.
Okay. So in the room, for example, where that photograph was taken, the only people in that room are you and Mr. Graham and the child, correct?
Yes.
Are there any other people at the church?
Working in the church? No, it's closed during the
Is it
week.
completely vacant except for you three?
Yes, unless somebody would, there was a man that mowed the yard
And
occasionally.
my question is that obviously the supervision is for the protection of the child according to what they agreed to. And I'm just trying to determine how much supervision there is and how much, there are other people around in the event of some incident. I know this gun incident that disturbed you, but all right, that's all I had to question. Thank you. You can step down. Mr. Holly, you may call your next witness.
That's our proof, Judge, other than closing argument a little bit.
Ms. Hendrickson, do you have any other witnesses you wish to offer? Any other proof?
I don't have anything else, Your Honor.
All right, I'll hear you in argument.
So, Your Honor, when I was researching on another case for another issue, I came upon a case, Schaffner versus Schaffner. It's a Court of Appeals case from Nashville. The citation is 181 Southwest 3D 703. In that case, it was a divorce case. There were medical doctors, parents. They have 3 children. The trial court found, and the trial court was upheld by the Court of Appeals. They found that both parties had faults in them, which you found in this case. Although the father had more serious issues there, the father was found to have physically abused one of the children. And the list went on and on for both parties as far as negative things about them. But in the course of their divorce, the father, according to the courts, both the trial court and the Court of Appeals, the father demonstrated that he had the willingness to change, albeit he was arrogant and all these things. The actions spoke. And the Court of Appeals even said, the record showed that the father demonstrated a genuine desire to be a better parent, while the mother refused to recognize her own shortcomings or the effects that those shortcomings had on all her children. The courts eventually awarded the father primary residential on one child, and then the mother, they split the 3 children, which doesn't happen much. But in this case, they felt the need to split the 3 children. And then the courts went on to say that parenting plans should never be used to punish or reward the parents for their human frailties or past missteps. And that's what we're asking the court. We're not representing that father is perfect. He, in his testimony, had admitted to his shortcomings more than he wanted to in the beginning. But as you know, true of everybody, like in my childhood, my mother would ask me to clean the kitchen. I was the youngest with 4 brothers, so you can imagine how many tasks I had to do. And so I would do it begrudgingly, but I would still do it because I knew I had to do it. And I feel like this is what we're seeing with my client. He comes off as the, all-knowing, and he would, he would admit that he thinks of himself highly and all these things. But you will see in his actions that he has a genuine desire to be a part of this child's life. He has bent over backwards, and he will continue to do so. And evidence proof showed that it was Mrs. Graham who is guilty of physically abusing the other party. And whether that rises to the level of domestic, we're not there. My client chose not to call the police on her. Proof showed that it was Mrs. Graham who had been overly aggressive towards this child. We heard the recordings. My client admitted that he was not very particularly proud of those. Those were all in the past. And here and now, we're not saying that those should not be considered. But also, I'm asking the court to consider the things that happened after that. There's no proof here that the child was subjected to any unsafe situation except for that gun situation where my client agreed to not bring the gun. He has demonstrated, like in Schaffner versus Schaffner, that he is willing to listen, he's willing to participate, maybe sometimes begrudgingly, but he would do it. On the other hand, the court will have to consider the factors here, best interest factors. Mother has continued to show alienation, and it's almost rising to the level that she just wants to terminate my client's rights. Because she still wants zero visitation for my client. It's almost like pulling teeth when my client wants a supervised visitation. And so I think that we have showed Your Honor that, and you pronounced yesterday that both parties have faults here. And again, there's no proof to show that my client is not fit per se to take care of Pearson unsupervised. It could be that it needs to be gradual just because they haven't had overnight visits. He has a suitable home. He has been providing for the needs of Pearson as much as he can, whenever he can. There's just no proof at this point, I believe, to justify the supervised visits. That's all, Your Honor. Thank you.
Mr. Hawley?
Sir, I know this may seem like a final hearing, but we are at a temporary hearing in this case. I think a lot of this boils down to credibility. This court has already given us some findings of fact from yesterday. I think that Mrs. Grammon's credibility definitely holds over Mr. Grammon's credibility. You've heard for one thing, the audios that have come about. If she hadn't recorded that, that would have been a flat out denial. You would have never heard of any of this. The mother has consistently been the caregiver of this child. The status quo was with the mother. You've heard the testimony that he never changed a diaper. You've seen the pictures of him. She's trying to show you that at a birthday party while they're eating cake, he's on the couch playing with his phone. That he has been recently smoking marijuana and drinking quite a bit to the point that he passes out. She cannot get him awake. The audios that you heard were recent, a couple of months of them actually separating. Their testimony has been, and it's been consistent, that Mr. Grammon is on a progression, getting worse and worse and worse. The anger and the anger management problems that Mr. Grammon has have been evolving to the point that she couldn't live with him anymore, and she separated. Started out, I guess the physical violence, which you heard, Judge, started out with cats, dogs, whatever, migrated into, Mrs. Grammon, and it gets to where it is today. I have people come in the office all the time, and I tell them there's two factors actually that this court, and I know this court will consider them every day, that if you're trying to deprive a parent of visitation, it's gonna, the pendulum's gonna swing the other way when you get to court a lot of times in situations. And I constantly tell people in my office, you need to give some visitation. It's something where you need to give some weekend visitation. There's gonna be a price to pay if you don't. When they played the recordings for me and they told me the situation with Mr. Grammon, in my defense, I couldn't very well say that. The last thing I want is to talk them into giving some unsupervised visitation and something happened, and then that's going to be Reese Holly's problem because I talked them into doing it, told them they had to. I didn't feel comfortable with it, knowing what I know, and you know everything now that was told to me in my office and was shown to me and played for me. And it's the court's decision at this point what to do in this child's best interest. We fully agree with psychological evaluations all the way around. If Mickey Smith will take this case, I think it would be a blessing. Everything that this court...
He will. I've already talked with her about it, and Ms. Smith has confirmed that she will take the guardian ad litem appointment.
Again, I think that would be a blessing to both of these parties to have a little Mickey Smith in their life. And my client's ready to definitely cooperate with that. The problem becomes from, as you hear from Mrs. Gramman and from all the witnesses, her mother included, that had to sit there at the church with a gun. It's an evolution of anger. And that's how he deals with it. I mean, you know, he didn't, at a visitation with just the mother, and this court asked those questions, there was nobody else in the building, but he felt like he had to put a gun in his back and pull his shirt up where she could see it, pardon me. That was nothing more than an intimidation factor. But my question becomes, as it is in these cases, what happens if Pearson destroys a charging cord? What happened if Pearson grabs something and runs off with it like the dog did? We're gonna, at some point, with an evolution of anger in this situation, you know, does Pearson get chained up to a jet ski? You know, he's got to learn how to deal with what's before him and how to deal with a child in these situations. He's not done a very good job of that. The track record is horrific to the extent that you're listening to the audio recordings that you've listened to, and his wife has left him, and the families are at odds, and all of those things. You know, but for the anger of Brian Gramman, you know, we wouldn't be here, I don't think it would have been a separation. We're asking for the status quo, that my parenting plan be adopted. The court lay down some sort of supervised visitation. Dr. Berryman will do it. Again, I think that would be a blessing. If not, let's get somebody for a psychological evaluation and somebody that can follow the recommendations of whatever those psychological evaluations may be, and somebody that can take charge. He's got great insurance from what I'm hearing that both parties can use, and somebody that can be involved on a day-to-day in the life of, whether it's Mickey Smith or whether it's the psychiatrist or psychologist that we choose, to introduce different types of visitations and different types of things when Mr. Gramman is ready. That would be, in our opinion, the ideal ruling, and let the professionals handle it, let them deal with how he needs to be dealing with his anger and help him with it so that nobody has these issues, and let them control the visitation. If they say unsupervised, then let them do it. Let them be in control of everything as far as that goes. We're asking for the status quo, especially until we get the psychological evaluation. Obviously, the drug test, I noticed he didn't take one when we came to court. I don't know if he will pass the thing or not. I'm sure with the court dates and everything upcoming that, you know, you kind of refrain from those things with the knowledge that you're going to be doing this stuff. When the immediate separation hit and all these things started, I noticed we didn't have a drug test during that time, although he did do all the other things. And the other things were with Main Street interventions. The court can take judicial notice. You've used them. I've been around them for years, and they do a great job. But Mr. Gramman's river runs a little deeper, and I think he needs more than a questionnaire to be filled out and those types of things. You said you're going to order that psychological evaluation. I think that's, again, a blessing for both parties. And I appreciate your time for hearing this case.
Anderson, you have the right to open and close. Anything else?
No, Your Honor. Thank you. I do think, Your Honor, you're gonna give your ruling and then we move on to the other motions that were filed in this matter.
And the other motions are?
I think I have a motion to enlarge the discovery request, which I'd be happy to discuss
A
it with.
motion to enlarge the discovery request.
Also, I had a motion to compel, and then I followed it with a motion, and then Mr. Hawley filed a motion to quash my second set of discovery. And then I followed it with a motion to enlarge the number of
Well, let's go ahead and deal with those. I'd like to
discovery
just make
requests.
one ruling on all of the issues. So your first motion is a motion to compel.
And Your Honor, this is basically hand in hand with the motion to enlarge. I previously sent my first set of discovery requests to Mr. Holly. It had 51 questions, not including subparts, but the subparts were related to the subject matter being asked on the individual questions. And then I got the discovery, but then there were 9 items that I listed in my motion to enlarge that were not answered. And so what I did was I sent a second set of interrogatories and requests for production and included those items that were not responded to, and then also added new questions based on the answers. And then, so that's when I filed that, sent the second discovery, and then Mr. Holly filed a motion to quash. And then I filed this request and a lot of these questions now have been answered from our hearing, but I'm still missing medical records of Mrs. Graham. She has testified that she has seen a therapist during the marriage. She didn't divulge that name in her answer, and now we found out that she did see a therapist. I included a medical authorization release form. I have it here. If Your Honor would be agreeable, she can just sign this and we'll send it to the therapist. And then the rest are questions about her actual employment, which she already responded to. And so that's my motion.
Holly?
Sorry, I filed kind of like a motion to quash I don't know how else to phrase it, the set of discovery. We have a rule, and I was in the room when it got invoked in 2000, I remember it well, 2006. Right after the election, Mr. Potter brought it up and Larry Wallace seconded it. We were all in there making rules to our amendments to our local rules. And one was that discovery would only have 50 questions, including subparts.
Ever heard the term that a rule is observed more in its breach than in its compliance?
I understand.
You ever see John Belushi when they were playing the Killer Bees on Saturday Night Live and said, "We don't need no stinking rules"?
Yeah.
Actually, he said no stinking badges, but this is a case, I understand your objection because of the multiple questions being asked. This is a case that's obviously not going to be resolved by agreement because these parties can't agree. But in other words, in my opinion, there's no reason not to allow these additional questions and to expand it. The local rules are that, and those local rules provide that the court may waive them with discretion. In this particular case, let them all have it. Let both sides put as many questions out there as they want to. I think it would be better for them to have full disclosure than it would be to limit what they're asking. And if there are questions about her therapy then my suggestion would be the following. If there's going to be a therapist records that are going to be requested out of confidentiality, and those therapy records are usually confidential, and the same thing's going to apply with these psychological assessments. They're going to be filed with the court, and they're going to be filed under seal. And only people who can get access to them are going to be the attorneys who represent the parties and the court. And by doing that, we're preserving the confidentiality, and the parties need to know that if they are giving full disclosure to their therapist or to the psychological examiner, that's not something that's going to be bandied about unless there's a need to do so that the court finds is relevant. So I'm of the opinion as to this therapist issue, Ms. Hendrickson, that there probably needs to be an agreement that her therapy records will be produced either by judicial subpoena to be filed with the court, and then you will have permission to review those records. You cannot copy them, but you can review those records, and Mr. Holly can review those records. And if there's something in those therapy records that you feel like would be relevant for a final hearing, then you can file a motion asking the court to allow you to do that, and we can have an in-camera hearing where I can review the records and I'll make a determination as whether or not that's something that's relevant enough to unseal it, so to speak, and go from there. But I don't see any reason that Ms. Hendrickson's request for additional information can't be reasonably agreed to. So let's go from there. So.
And in the judicial subpoena, the records show up here, is it, Your Honor? And I've done this a couple of times with this court. Usually it's the order that I can look at them, Ms. Hendrickson can look at them, but we can't even tell our clients until we file that motion and come back in front of you. We can't talk to our client.
You cannot reveal what's in those records until after you've got permission from the court to utilize it. And if there is a lot of extraneous information that has nothing to do with this case, then there's no reason for that to be that breach of confidentiality. If there is information in there that's relevant on the issues before the court, then you can apply to have that information provided.
I just know we're gonna have this, but even to our own clients, we can't say anything. We've got to come ask you, and then we can talk to our clients about what's in the record with each other, so.
You as officers of the court are under a sworn duty to follow the court's instructions, and as you well know. So what I'm doing is simply saying, this is about discovery. So if you discover something in those records that you feel like is notable and usable in the case, then and only then can you come to court and say, I want to use this information and I want to disclose it to my client. I'll consider it and I'll give you permission or I'll deny that, depending on what I think it is.
The biggest question comes up is, why can't I tell my client? We always say that. I just want to make sure we're clear.
The clients are sitting in the courtroom and they're listening to what I say, I hope. And so for that reason, what I say applies to them. Your lawyers are officers of the court and they're ethically bound to follow this court's instructions and not to do what necessarily their client wants in this situation. So, all right.
And that pertains to the discovery request now is wide open on both sides. May I have 30 days to answer what I've got in front of me with the second set of discovery at this point. So I'll round that up and get it to her.
You fire away.
Thank you, Judge.
Fire and fall back.
That's the only,
The only request for your consideration is I have previously sent a draft agreed order to Mr. Holly, basically asking for the parties to not expose the child to any person of romantic relationship or anything like that until this matter is resolved, if you would consider that. And that's
Okay,
all.
well, you gonna make that a part of your final, are you gonna make a closing argument on this case? We're ready to take up your argument. Have you already done enough of that you want? So the only other thing then is your request to have a mutual prohibition in the final order that prohibits either of them from making that, allowing the child to be around someone that might be construed to be a paramour. Do you have any objection to that?
I know there was a motion before the court for that right now.
It was not it was not a motion. I sent you a draft order, agreed
It was a
order.
proposed agreed order.
proposed degree.
And the reason why we're asking that was the issue of the child calling my client his full name, Brian Graham, at some point, and then it changed to Daddy. So he wanted to make sure that the child doesn't have any ideas that he's being replaced or anything like that.
There's not a problem with this on our side. I think this is something that's thrown out there to make my client look like something's wrong. There's nothing wrong. She's not seeing anybody. There's never been any evidence to that effect. But if that's what we need, is an agreed order from Ms. Henderson, we're fine with it.
All right, we can put that in your order. All right. Ms. Hendrickson cited the case of Schaffner versus Schaffner of the 2004 Court of Appeals case that was cited at 181 Southwest 3rd, 703. Mr. McKinney has pulled that case for me, and I've reviewed it. And the part that Ms. Hendrickson quoted was, parenting plans should never be used to punish or reward the parents for their human frailties or past missteps, and that's very true. What was not quoted was the preceding language, so I'll quote that now. Court of Appeals stated as follows: creating a parenting plan is one of the most important decisions confronting a trial court in a divorce case. Courts must strive to devise parenting plans that promote the development of a child's relationship with both parents and interfere as little as possible with post-divorce family decision-making. The needs of the children are paramount. The desires of the parents are secondary. Parenting plans should never be used to punish or reward the parents for their human frailties or past missteps, but rather they should be used to advance the children's best interest by placing them in an environment that best serves their physical and emotional needs. There are no hard and fast rules for devising a parenting plan. The process is factually driven and requires the court to carefully weigh numerous considerations. The Tennessee General Assembly and the courts have identified many of those factors that the courts must consider, and of course they quote the Tennessee Code factors that are set forth in 36.6.106 of the Tennessee Code. Trial courts have broad discretion in fashioning parenting plans that best serve the interest of the children. They must, however, base their decisions on the evidence presented to them and upon the proper application of the relevant principles of the law. So therein lies our, that is a complete reading of the Court of Appeals decision in the Schaffner versus Schaffner without relying on what they actually did in that particular case, because that case was more about issues that weren't directly about it. It was a different judge had come in and taken over a case, and so much of the case is deciding with, or dealing rather with a successor judge and how he handled the case. But there was that applicable information. So it is not this court's intention to punish either side in this case. Neither of you is perfect. I rarely see a case in this court that reaches this point that one side is without fault and the other one is completely to blame. Rarely ever, and in fact, I don't think I've, in now almost 9 years on the bench doing this and all my years as a lawyer, I don't think I ever had a case as a lawyer, nor have I had one as a judge where one person was completely and absolutely completely at fault. There is one that comes to mind, but that person is presently, that defendant is presently serving prison time for sexually abusing his daughter. And to my mind, that's the one case I can call to mind where all fault lay on that person's side, despite his efforts to try to say it was his daughter's fault for him sexually abusing her. In any event, I digress. This is not particularly an easy case, and I want you both to know, and I take it very seriously. At 3:30 this morning when I awoke for some reason, first thing to my mind was, how am I going to deal with this case? I have already appointed a guardian ad litem. Mickey Furlong Smith is the attorney that's going to represent the child's interest in this case, and I think that's an appropriate situation. I previously ordered that a psychological evaluation for both parties they'll undergo that. We'll hope that Dr. Janie Berryman can do it. If she can't, she'll refer them to someone. I want them both to undergo a parenting assessment. Parenting assessment is different than a psychological evaluation. Psychological evaluation is designed to determine and to identify if there are psychological issues. Hopefully, if Mr. Grammond has, gotten hold of his anger issues, and there clearly are anger issues by his own admission, then that would be one thing that the court can consider what he's done so far, and the psychological evaluation may determine whether there's a need for additional steps to be taken in that regard. But the parenting assessment is something different because it does assess the abilities of both of the parents and what their needs are in improving their parenting skills. As I said yesterday afternoon, Mr. Grammond is this child's father. He has a right to see this child. I understand you don't like him anymore, you don't love him anymore, that you don't want to be around him anymore, but the child has a right, and I just read to you that my obligation under the law is to fashion a parenting plan that will allow the child to have a good relationship with both parents. This is a temporary parenting plan, so therefore it is not the same standards, so to speak, as a permanent parenting plan. But nonetheless, I'm being asked to determine, Ms. Hendrickson on behalf of Mr. Grammond has asked that the court fashion a parenting plan that gives equal time with him and designates him as the primary residential parent. So I'll look at these factors that the code has set forth for me to make this determination that I'm required to look at. Those are set forth, as I said, in 36.6.106 of the Tennessee Code. The first one is the strength, nature, and stability of the child's relationship with each parent, including whether one parent has performed the majority of parenting responsibilities relating to the daily needs of the child. Clearly, Mrs. Graman has performed the majority of the parenting responsibilities relating to the daily needs of the child, and the court finds that factor favors Mrs. Graman. Second is each parent or caregiver's past and potential for future performance of parenting responsibilities, including the willingness and ability of each parent and caregivers to facilitate and encourage a close and continuing parent-child relationship between the child and both of the child's parents, consistent with the best interest of the child in determining, that factor, in my opinion, doesn't favor either of these parties, because I don't think that either of them have shown a willingness and an ability thus far to encourage a good relationship with the other parent. There's too much animosity and hatred, I guess you could say, outright between them. As a result of that, and while you can come up to court and you can testify about all of the changes you've made in your life, you have to understand that the court doesn't just judge it from what I read in the file and what I see from the witness stand. I also observe people in the courtroom. I observe how they act and how they react to testimony in the court. And frankly, the testimony has been about this gun episode. I will say this, that clearly, and it goes to other factors set forth in the code, but this situation of the need to carry a pistol demonstrated in the back of your pants during a visitation with only your mother-in-law and the child in a church that's otherwise deserted is ridiculous. You have every right to carry a gun, but to carry it to a visitation with your minor child is intimidation. And that the court finds was an effort by you to intimidate the supervisor of that visitation. And the court has observed in this courtroom yesterday during a lull when we were waiting for someone, I observed Mr. Graman staring at Mrs. Graman across the room. And that went on for quite some time. And the only reason for doing that for that length of time was, in this court's opinion, an attempt to intimidate her if she looked at you. You may not have understood that I was observing you, but I did. And, you know, that kind of stuff is high school stuff. It doesn't need to be in your life anymore. You're going to get to see your son. We're going to move to that situation. You're going to have, at some point in your life, unless there's some factor that comes back up, you're going to have a liberal visitation with your child, regardless of who the primary residential parent is. But you are not going to be able to intimidate her anymore, because I'm the one who's going to be making the decisions, and you certainly don't intimidate me. So I'm just telling you, stop that if that is in fact what you intend to do. And perhaps I've misinterpreted it, but it certainly appeared to me that's what's going on during the supervised visitations. I've dealt with the fact that will no longer be allowed. You will no longer be allowed to take a gun to the visitation or to demonstrate it, and we'll go from there. You have a right to have a gun on any time you want to, except your rights are subordinate to this court's obligations regarding your child. When you two can't agree on something, you surrender certain rights to come into this court. And that's one of those, is the right to make decisions for your child. I have to make them. I don't want to, but it's part of the job that I've assumed. So I'm just telling you that everything you do is part of what this court has to consider. So that's a factor the court doesn't find, because Mrs. Graman has simply said she'd rather even not see this child at all. She's following her lawyer's recommendation, because Mr. Hawley knows that he's got a right to see them. But she's indicated that she doesn't really want him to see the child. That's going to have to change, Ms. Graman. You're going to have to come to grips with the fact that you had a child with this man, and the only time the termination of parental rights is one of the most severe things that can occur in any person's life. Is one of the highest burdens upon a court to terminate a person's parental rights. We have all sorts of rules and regulations. It requires clear and convincing evidence. That's the highest standard in a civil court is clear and convincing evidence to terminate someone's parental rights. So you have a father of your child that you're going to have to deal with for the next 16 years. And you better get used to that idea that you're going to have to deal with each other. That goes with you, Mr. Graham. So court finds that there's been no refusal to attend a parenting educational seminar. He has done so. I don't remember if she has or not, but she'll have to do so before the conclusion of this case. The disposition of each parent to provide the child with food, clothing, medical care, etc. She's been the one who's primarily taken the child to all of the doctors and taking care of feeding and clothing and bathing the child to the large extent. He has participated, but he's also provided some support voluntarily without a court order, and that goes to his credit. The degree to which each parent has been a primary caregiver, I've already determined that she was the primary caregiver in the past. The love and affection and emotional ties existing between each parent and the child. I hope that Mr. Graham is truthful and honest with me yesterday when he said the only thing he's ever wanted in his life was to be a parent, to have his own child, because that is one of the most awesome things you can have happen in your life, but it's also one of the most challenging things that you can have. Your child is now in the so-called terrible twos, and it's going to be a challenge from this point on for both of you to deal with a child like that. And it's going to get worse because he's going to be going back and forth at some point between your homes, and children start to manipulate their parents by their behavior when one parent lets them do something the other one doesn't. So you better get used to that idea. But both of you, I think, love this child, and I think both of you have the desire to have a good relationship with the child. So I think that's an equal factor for both. The emotional needs and development level of the child. This is a 2-year-old child. I don't have any indication that there's any problem with emotional needs, so that doesn't really apply in my decision. The moral, physical, mental, and emotional fitness of each parent as it relates to the ability to parent the child. This factor causes the court some great concern, and that's the reason I've ordered the psychological evaluation. You cannot listen to the tape recordings that were made, the audio recordings, and I'm not naive enough to think that someone who's going to record someone who's ranting and raving of their partner is going to avoid engaging in that same type of behavior. In other words, rarely ever are you going to see someone who's going to record something that goes off and starts using the same type of language. They record you at your worst, and they record themselves being very calm and mild. And there's nothing wrong with that. I'm just simply saying that I also understand that that shows only one side of that equation. But it cannot be that you can listen to those recordings and not determine that Mr. Graham has some issues regarding his anger and his behavior. And therefore, that's the reason that I ordered a psychological evaluation. And I wanted to have a psychological evaluation of both parents for that very reason. I find that factor favors Mrs. Graham at the temporary hearing, and we'll see what the psychological evaluations reveal. I don't find that there's any interaction with siblings or other relatives with this child that would affect my ruling. The importance of continuity in the child's life, the length of time the child has lived in a stable, satisfactory environment. The child has primarily been with Mrs. Graham, and that factor favors her. Evidence of physical or emotional abuse to the child or to the other parent or any other person. There has been evidence on both sides presented, and both sides have testified. Mrs. Graham has candidly said, yeah, I've slapped him, or I've hit him, that it was in self-defense. She testified she kicked him because she was exhausted and laying on the bed, and that situation happened. He says that she has laid her hands on him, those are his words, and that she's physically abused him. That very well may be. I don't find that the credible testimony before the court substantiates that Mrs. Graham has been physically abusive towards him. I also don't find that there's been physical abuse towards this child by Mr. Graham. There has been clearly some evidence of physical abuse. I have to judge credibility from what I see. And when I hear that Mr. Graham, who is substantially larger than his 4'11", 187-pound wife, says that she has physically abused him. I'm not saying that can't happen, but it's not likely in this court. It's not as credible in this court's opinion. But in any event, that stops now. There'll be no intimidation, no threats, no violence that will take place whatsoever. Neither of you will physically abuse this child. That'll be a part of this court order. Neither of you will use corporal punishment. Why? Not because I was whipped as a child. That certainly happened to me. And there were times when I was raising my children that I might have felt it was necessary, but you put it in my hands. I don't know you well enough to know what level of physical corporal punishment you'll use, but you're not going to use it now, period. We're just going to eliminate that as an issue. Put them in the corner, deny other things, but there'll be no whipping or corporal punishment used. The character and behavior of any other person who resides or frequents the home of the parent. There's no evidence before me of any other person. Reasonable preference of a child doesn't apply. The employment schedule doesn't really apply. The other factors deemed relevant by the court. As I've stated, in my opinion, the implementation of the gun and the visitation is a major red flag for this court, and for that reason, the court finds that is a factor that also applies. So all of these factors combined indicate that Mrs. Gramman will be designated as a primary residential parent of the minor child on a temporary basis, and this is temporary. I have ordered that a nail bed test be performed on both these parties within 48 hours. There are two different labs, and Ms. McKinney has obtained them for you. I'm not going to, one of them is Relia Lab at Suite 109, 3656 Trousdale Drive, Nashville. The other one is Anytime Labs, which is on Wilma Rudolph Boulevard in Clarksville. And either of those is satisfactory. But I think council would probably benefit by having both of them go to the same lab so that there's no question about how the lab performed the test. Both of them will submit to that within 48 hours, if at all possible. If they can't get an appointment until next week, then so be it. But I'd like to try it done as quickly as possible. I'm going to look at those. We're going to continue the supervised visitation for now, and I want to make it clear, I'm only doing that because there's been evidence of drug use. Marijuana is illegal. Other situations, I listened to the recordings and what was said during the recordings about alcohol use. I've also listened to Mr. Gramman, who says he's quit drinking, quit using drugs and that sort of thing, and he clearly encouraged and wanted to take a drug test. So we'll see what this nail bed test shows. Hopefully that'll resolve the issues. The supervised visitation will continue. We'll keep it in the status quo right now, but on November the 30th, I want you back in this court. And I'm going to review the nail bed drug test results. If those come back clean, then Mr. Gramman can expect that I'll move towards unsupervised visitation of some form. And I can't just give you unsupervised visitation right now, Mr. Gramman, without some sort of reassurance that what you tell me is true. So I want to have this test. Now, the length and time of that unsupervised visitation will be up to me at that time, and we'll see how things go between now and then. The behavior that you two demonstrate towards each other between now and the 30th of this month will help me to determine how much visitation, how long, and under what circumstances. But if it does go to unsupervised visitation, and you take your son to this apartment you're renting, he doesn't need to have any contact with the other inhabitants of that retreat. I understand what you're saying, that that's but I've dealt with these kinds of situations long enough to know that those boys are not being sent there for a private school like you would send them to BGA or MBA or some of those other private schools. They're sent there because they have some issues. It doesn't make them dangerous, but it does make them children who have, some sort of issues in the past. So as a precautionary matter for this court's protection of the child, if you get unsupervised visitation, you take your son there, we're going to prohibit him having contact with those boys. It's a simple thing. And I believe that deals with everything that I have dealt with right now. And the court is of the opinion that if the nail tests come back negative, that the parties would be well instructed and advised to try to set up some sort of short unsupervised visitation periods, because what I intend to do, if it comes back clean, and the guardian ad litem is involved and unless the guardian ad litem has some objection, then we're going to start with some shorter unsupervised periods moving to longer as we go. that's a test run, so to speak, Ms. Graham, so that you see that. I want to reassure you that your child is safe. I want to reassure him that he has a future waiting out there, that it's kind of like the old carrot and stick approach, where you essentially say, here's what you can work towards, and if you do that. I compliment Mr. Grammond for doing the things that he's done to try to get himself straightened out. He's got a good lawyer, very thorough. That's evidenced, both of them are very thorough, as evidenced by this being the third day of a temporary hearing. But the fact of the matter is that you follow her advice, follow her instructions, as I think you have done at this point, and we'll see where we are on the 30th. But there'll be no guns involved in the visitation, and I strongly urge you to get along with your mother-in-law at this point. She's the supervisor, and let's don't have any kind of problems and so forth, and then we'll go from there and see on the 30th. But I would really hope that on the 30th we can start moving towards unsupervised.
I do have a couple of questions, if it's okay.
I'm up here so I can make sure I hear you.
Your Honor, on the continued supervised visit, we would request for a specific day so that they won't have to have that conflict with trying to arrange. Would that be possible?
Sure.
My client is
What time do
always
you-
off during the weekends, and
What
then
time
he
do you
gets
get
off.
off? You're flexible, right? That's what you
I
said.
can be flexible. I'd prefer to start.
You have a day, right now you're having a day during the week and an afternoon during the week and during the day on Saturday, correct?
Yes, sir.
All right, what day during the week?
It varies between Monday, Tuesday, Thursday, whatever she tells me.
Tuesdays. We're going to designate the day will be Tuesdays. And
I do want to consider their supervisors as well, just to make sure
That they're okay with Tuesdays.
I can check. Before, it's been kind of with what the supervisors can do. We got the Fords and then her mother.
I'll take a recess. I want to designate one day, one afternoon during the week, and Saturday for the length of time, Saturday that's been doing from 10 to 2, I think is what you've been doing. That's temporary, and keep in mind, this is all until we come back on the 30th, okay? So between now and
every
then.
weekend, every week.
Every week, he needs to see the child 2 times, one during the week, one on the weekend. It can be Saturday or Sunday, but I'll take a recess and let you all try to work that part out.
I do have one more question, Your Honor.
Right of that.
I have been researching the nail bed, and I can't find where it says how far back it goes, because my client did testify that he had his last, I want to say May-ish. So I just don't,
Your client
if it's-
testified he was willing to take a test and let it go back as far as it possibly could. I'm going to take him at his words.
but we don't know how long that goes for.
I don't offhand, but I'm understanding that it may go back as much as 6 months.
I'm fine with that.
That's all, Your Honor.
Good
Thank
with
you.
that.
I think you kind of have to order both parties not to cut their nails till they can go take the test. My problem with those is everybody comes back with insufficient
I'm
samples.
inclined, if they cut their nails, we'll just pull them out.
Well, that's what they do at the nail bed place. I mean, I've seen some of them come back with just bloody it's one of those things. Anyway, if this
I've
works?
actually had cases before me where somebody was ordered to take a hair follicle test, and the next thing you know, they have shaved every hair on their body. A man shaved every hair on his body, and to avoid being able to take a hair follicle drug test until it delayed it, but didn't.
My
They
favorite
take
was
toenails, Your Honor?
they will.
Because he's got really short fingernails, but he's got longer toenails. I just want to make sure, Your Honor, I'm being transparent here.
They will use toenails.
Mr. Graham might not want to bite his fingernails, because they may take a pair of pliers and pull on those fingernails, so.
That's what it takes to get piercing done.
Okay.
Well,
I think they would take nails of any, nail bed of any
Okay.
kind, toenails or anything else, so just don't clip your toenails short.
it would be agreeable with a couple of days' notice somewhere where it could be Tuesday or Wednesdays, and we can get one of those.
Sorry, what?
A couple of days' notice, maybe we could do a Tuesday or Wednesday. We'll do one of those 2 days.
You're
by
gonna
the
decide
agreement.
that today. We're not leaving here until you two have decided what the days are gonna be. So you're gonna stick around, you're gonna find out from these supervisors by phone what day they can do it, and we're gonna set that as a part of the order, because all it's doing is, the next thing I know, you two are not going to be able to agree for some reason, and then I'm going to be getting phone calls or messages that the visitation can't be agreed upon. We're going to fix that today so that it's set and certain.
And
Fair
then
enough.
the duration for the visit, how many hours?
The duration of the visit has been, I think, in the afternoons, 2 hours on Tuesday, during the week.
3 hours, Your Honor.
2 hours, 3 hours,
Well,
2.5 hours.
Well, if
2 or
it's
3
only
hours,
twice
you
a
tell.
week, we would ask for 3 hours. You know what we would propose for the weekday, 3 hours, and then Saturday, 4 hours.
I don't think I have a problem with that. I'll talk to them.
3 hours in the week, 4 hours on the weekend. You all talk to these supervisors. I am fine with it being between now and the 30th. One day during the week, designated Tuesday or Thursday, whatever you want to do. I figured Wednesday is going to be church night at the Alexandria Church of Christ. It's like the Churches of Christ I grew up in. They're going to have church services, so it's not going to be a good time to do it. But if you do it Tuesday or Thursday, one of those 2 days, just do that day, because that gives you time in between the Saturday or Sunday visitation. So you can do Saturday one week and Sunday the next week if you want to. I don't care, Sunday afternoon or whatever, but I think it makes more sense to do it Saturday. So my inclination is see if you can get your folks to agree to Tuesday afternoon for 3 hours and Saturday for 4 hours.
So we want a Tuesday or Thursday and then a Saturday, and if not, they can go to Sunday. I think we can work that out without you taking a recess, I would hope, so. I'll be glad to do that.
This information says on average, most drugs detectable in fingernails beginning at approximately 7 to 14 days after use and extending as far back as 3 to 6 months, depending on the length of the nail clippings that are collected. Confirmed positive result for a drug or drug metabolite is considered evidence of use or exposure in that time period. Note, toenails do not grow at the same rate as fingernails, therefore the window of detection is less precise. This test requires the clippings of all 10 fingernails or 10 toenails. Fingernails and toenails should never be mixed in the same sample. All right, so nobody clips their fingernails or toenails between now and then. Is there anything else I can address for you folks?
Can we make sure we have an insurance card from his insurance for the psychological evaluation?
Insurance cards need to be exchanged.
And then guns, or can we say any other weapons at the visitation? You heard her talk about
Knife needs to
knives.
stay out of the visitation as well. There's no, I mean, I understand that's probably a belt knife or something like that, or maybe one of those clip-on folding knives like whatever, or utility knives, but just leave anything that might be interpreted as a weapon outside during the visitation. That goes for your supervisors as too. I mean, this goes to the Fords or anyone else. They don't bring knives or guns to this as well.
November 30th, I'm having some outpatient surgery on the 27th. They tell me I'll be going home that day and all, but I may be out for the week. I don't know that I will, but just as a safekeeping, if we do this on the 30th, may I do it by Zoom?
Yes.
Or any things I've got that.
This
week
is
by
just
Zoom,
for me
so.
to try to give, to see what the results are, hear from the guard ad litem, see where we are on the psychological evaluations. And if there's no presence of drugs, you know, or that would cause concern, then, you know, I'd like to then go ahead and try to start support some
What
sort
time
of.
would that be, Your Honor? Because I'll be in Davidson County in the morning, but I should be done after noontime. Can it be put in the after, second call?
30th.
Plenty of stuff to go.
We have a big docket that day, so if you need to go somewhere that morning, Mr. Holly will probably be in his pajamas that morning anyway if he's had surgery, so we'll see if we can get him up and dressed in time for that afternoon.
Mr. Holly hopes to be in the suit right here, but just in case.
Just let the clerk know what time, but we'll be here at least at 1:30, so.
Thank you, Your Honor.
Anything else?
You want me to actually go check and come back in real quick?
Yeah, I've got another case that Mr. Atchison is involved in, that we're gonna take a recess before we get to it.
I'm sorry, Your Honor, we forgot one more thing. The phone calls twice a week.
Do what?
The phone calls or FaceTime twice a
That's
week.
standard parenting, and if you can do a FaceTime call, that's even better, although that may not necessarily, you got a 2-year-old, And my experience with trying to FaceTime my 2-year-old grandson is that there's not a lot of cooperation on his end. He kind of stares at the phone and then wants to go play. But phone calls with a 2-year-old are not going to be great, but you can try the phone calls over FaceTime, whichever way it works. State parental rights is for at least 2 phone calls per week. So,
Thank you, Your Honor.
before I stand up, Senator, is there anything else?
No, I'm not doing anything.
We'll take a 15-minute recess.
All rise.
Thought I was finished with you. Did you agree on your schedule?
I thought I could leave, I already would have, if that helps. Yes, Judge, Tuesdays 4 to 7, Saturdays 10 to 2. If we can put in there or by agreement of the parties, if somebody's sick or whatever, they can text and make an arrangement, but if they don't have an agreement, those would be the dates and times.
All right, and that is true, Mr. Holly. What Mr. Holly states is the general rule, and that is, this becomes a court order, and I'm going to approve it today, so it becomes effective now, right now. And that means that if you're in agreement with that, that's fine. If you don't agree and you need to change something about it, it has to be by mutual agreement. And that probably needs to be through the attorneys, although you can do it by text message or something like that if that's what, just needs some sort of written verification that there is an agreement to alter it. But unless you two can both agree on a change, then you're stuck with that. So, all right, good luck to you. I hope this all starts to calm things down between everybody and that everybody starts to realize that you got to live the rest of your life. And the way that tensions and emotions are right now are going to make it very difficult for you to have a productive life and for your child to have a productive life unless you can kind of calm things down and start moving in a more positive direction. So good luck to both of you. I hope it works out.